President Biden celebrated Pride Month, and we're going to talk about that. But also his department, USDA, announcing that they are going to take monies, federal monies, that fund school lunch programs away from states unless these schools change their bathroom policies to allow boys, biological boys, to use girls' restrooms and locker rooms. Here to talk about this, Meg Kilgannon, former member of the Trump Department of Education and now senior fellow here at the Family Research Council. Meg, tell me that I just read this wrong and that's not really happening.
Well, I wish I could tell you that, Tony, but I'm afraid that it is happening. And fortunately, attorneys general from across the country have called out the lie of this effort on their part to completely ignore legal rulemaking processes. What the USDA did was to just issue an edict. They claim that they are clarifying a rule that they've already made, when in fact they're completely changing the interpretation and the application of that rule.
So you have 26 attorneys general that have written a letter to the president calling him out on his administration out on 2 points as it pertains to this. But again, I want to be very clear. I mean, this is almost like, it's just hard to believe. You have the Biden administration bullying schools, threatening to take their lunch money.
Yes, and without going through any sort of pretense of legal action to do so.
All right, speak to that for a moment, because having been in the Trump administration, when an agency is issuing guidelines and rules that states or others have to live by, there is a process.
Yes, there is a process. There's a suggestion of the rule. It's reviewed by the administration. It goes through review in the agency. It's reviewed by the public, and the public offers comments on the rule. And then it is revised again, and that input is considered, and then finally the rule is issued. That's not what happened here.
Didn't we have something similar to this during the Obama administration?
Sure. The Obama administration issued a Dear Colleague letter to school principals and administrators demanding the same sort of treatment for transgender identified students, that they be allowed access to everything based on their gender identity, not based on their actual sex.
And what that does for a lot of left-leaning school districts is that they say, oh, we've got to do this. And
Right.
So they throw this up in the face of parents and say, well, we're going to lose this funding if we don't do this.
Right. And even when in the Trump administration we rescinded that guidance, schools would still refer to the Obama guidance as the justification for their proceeding with the policy they actually wanted to adopt.
So we have one is they did not go through the proper rulemaking process. They're using this as guidance, but many will throw me into that briar patch. I'll do that. But then secondly, in their guidance, they completely misread or misinterpret or misuse a Supreme Court decision. Explain that.
Yes. The Bostock decision that came down in 2020 was a case that applied to Title VII, which is labor law, that's employment law. It does not have to do with Title IX. And they actually wrote in the Bostock decision, which was still not my favorite decision the Supreme Court has issued, they wrote that the interpretation they had for Title VII did not apply to Title IX. Title IX had not been considered, and that should not be construed as justification.
Their decision in Bostock dealt with employment law.
Correct.
And we're talking adults.
Correct.
And so the Biden administration is taking that Supreme Court decision that was about employment, and they're applying it to education and children.
Correct. Yes. Because it's convenient for their desires.
And they're telling states, if you don't fall in line, we're going to beat you up and take your lunch money.
If you don't illegally follow this illegal rule, we're going to take your lunch money. And not adult lunch money, children's lunch money.
But explain, again, you were in the Department of Education, you understand this. Explain who's harmed by this.
The children who are in Title I schools, any child who's getting a lunch that is provided by the U.S. Department of Agriculture grants that fund our school lunch programs. Those do not go through funding through the Department of Education. This is a Department of Agriculture funded program. They also fund things in soup kitchens, food pantries at times. So they're literally taking food away from hungry children. Some children, unfortunately, the only hot meal they get is the one they get at school every day.
So, again, I mean, I'm sure folks, you're listening to this, you're saying this can't be. This can't be. The President of the United States would take food out of the mouths of children, hungry children, in order to advance this radical transgender agenda, forcing students to be exposed to children of the opposite biological sex. I mean, how perverted, how demonic can you be? I mean, this president is, I would say he's got to be, I can't understand how you can be so obsessed with this agenda that you would literally take food out of the mouths of starving children.
I mean, what they're saying is that if there is a young woman who is in the band, for example, and they are traveling to play in a parade somewhere. Maybe they're going to the Rose Bowl parade in California, and they're going to be sharing hotel rooms. So there'll be 4 students to a hotel room. So if a young woman is in a hotel room with a boy who has boy body parts but identifies as a girl, that young woman who objects to sharing a bed with a male-bodied person is going to be considered the one who's discriminating against him based on his gender identity.
What about her rights?
What about her rights?
Yeah.
What about the boundaries that she should rightly set for herself?
I mean, this is absurd. And folks, look, not making this up. In fact, as I said, 26 attorneys generals have assigned this letter to the president saying you're wrong on 2 accounts. You need to rescind this order. You got the Attorney General of Tennessee, Alabama, Alaska, Arizona, Arkansas, Florida, Georgia, Idaho, Indiana, Kansas, Kentucky, Louisiana, Mississippi, Missouri, Montana, Nebraska, North Dakota, Ohio, Oklahoma, South Carolina, South Dakota, Texas, Utah, West Virginia, Wyoming, and Virginia. I guess the question would be, if your Attorney General has not signed this, they ought to. Find out, and if they have, send them a note and thank them. But you ought to ask your Attorney General, are you standing up for the children in our schools that their lunches won't be taken simply because we won't allow biological boys to go into girls' locker rooms?
Right, and perhaps some of the COVID money that schools have that has already been distributed to the states and is yet to be spent can be targeted to school lunches if a state does in fact lose their funding wrongly over this issue.